Hi, Bill Hammond here. I'm here today to talk about planning for the Alzheimer's patient, and specifically we're going to talk today about legal planning for the Alzheimer's patient. Now, what is Alzheimer's? Well, Alzheimer's is a form of dementia, and if you talk to medical professionals, they'll tell you that there's probably, I don't know, maybe 70, 75 different types of dementia. And what that really means is it means a lessening of the cognitive ability. It just means that you're having trouble remembering, thinking not quite as clearly, and it can be caused by a number of things. It could be anything from a thyroid problem to a vitamin B deficiency. Depression can cause dementia, all kinds of things. Well, today we're going to talk about Alzheimer's specifically, and of course, when we talk about that, it's one of the great fears that so many people have. You know, they say things like, geez, I'm having trouble remembering where I put my keys. Do you think I have Alzheimer's? And, I always tell them, well, in a case like that, it's not that you can't remember where you put your keys, because all of us have got so many things going on nowadays, we have trouble remembering. It's when you find your keys and you don't know what they're for that maybe we have some issues to deal with. But one of the things that we always talk about when we talk about planning for someone with Alzheimer's is it's so very important to get things done while your loved one still has the legal capacity or the legal ability to make decisions. And the law is very strict on this. The law says, first of all, that anyone over the age of 18, if they have not done a power of attorney, if they have not given someone the ability to act for them, they must have meant not to do so. In my elder law practice, I all the time come across families who have a loved one with Alzheimer's. And perhaps we've got a married couple that's been married for, 40, 50, 60 years sometimes. And they just never thought about doing powers of attorney because they always thought, hey, we can just take care of things for each other. Well, that's really not the case. The law says that even if you're a married couple, you do not have the authority to act for the other person unless they have specifically given you the right to make decisions for them. Now, if you've heard me speak, you've probably heard me tell the story. I have 5 children, and on their 18th birthday, every one of them comes into my law firm and signs powers of attorney. The reason they do that is because up until the age of 18, my wife and I can make decisions for them. But once they hit 18, we no longer have the ability to do that. So it's so very critical, if you have a loved one who has Alzheimer's, or if Alzheimer's is suspected, or if we have memory loss that's severe enough that the family is starting to wonder about it and worry about it, really crucial that they get powers of attorney in place. Now, there's 2 different types of powers of attorney. The first is a power of attorney for finances. And that's a document that says, as long as I can make my own decisions, I'll make my decisions. But if some point down the road I can no longer make decisions, then I'm going to appoint, my spouse, my child, whomever, to make those decisions for me. And the financial one has to do with things like real estate and taxes and bank accounts and anything that can be done from a financial perspective. Very important to get that done. The other type of power of attorney is a power of attorney for health care. That's a document that says, as long as I can make my own decisions regarding doctors and hospitals and medication and nursing homes and anything healthcare related, I'll always make those decisions. But if at some point I can no longer make those decisions, then by giving someone the authority to act for me, they can step in and make decisions for me. What happens if your loved one with Alzheimer's gets to the point where they no longer have the legal capacity or the ability to grant someone a power of attorney? Well, in that case, then what has to happen is the family has to go through a process called a guardianship and a conservatorship, and the court has to appoint someone to make decisions for their loved one. Now, we will deal with the guardianship and conservatorship issues in another video, but suffice it to say that it's a situation where, if at all possible, we want to avoid the guardianship and conservatorship. We always want to have the families, in charge, have the loved one who has Alzheimer's, pick out who they want to handle things for them. And so it's really critically important, if you have a loved one with Alzheimer's or who is experiencing memory loss, get the powers of attorney in place just as quickly as you can. Beyond that, there may be some other things that you'll want to consider. For instance, you might want to consider a last will and testament. That's basically a document that says, at my death, this is where I want my property to go. To my spouse, to my children, to charity, whatever it is. One of the challenges with a last will and testament is that anything that goes through a last will and testament goes through probate. Most of my clients want to avoid probate, and there are several ways to do that. One, of course, a very simple way, is to just set things up in joint names, perhaps a husband and wife, perhaps the parents along with the kids, and that's a way to pass property without going through probate. The problem is that it doesn't allow for any of the subtleties that sometimes happen during life. For instance, perhaps we need to pass assets down, to a child who has special needs. Or perhaps we want to have assets go in unequal amounts to different kids. Perhaps, one needs the money, one doesn't. All those types of things. And it can be very difficult to set that up just through beneficiary designations. One way that people then in those situations arrange their affairs is they put their assets into what we would call a revocable living trust. And that's a document where we would set it up. For instance, a husband and wife might both be what we call the grantors. They're the ones who set up the trust. They would be the trustees. They're the ones who manage the trust. And at the death of the first spouse, they might pass everything on to the survivor, and at the second death on down to the children. But for Alzheimer's planning, we have to go a step further. We have to make sure that if we set up a trust, we do it in such a way that we're not boxing the family in. Because keep in mind, while your loved one with Alzheimer's may absolutely have the capacity to make decisions right now, if we look further down the road, 5-10 years down the road, perhaps they may no longer have any recognition of the family whatsoever. So we need to make sure that the documents are drafted in such a way that not only will they avoid probate, which is what's important to the family, but also so that things will be set up in such a way that we don't have any problems as far as Medicaid qualification is concerned. We want to make sure that we've taken into account issues like, perhaps, if we have a husband who has Alzheimer's and his wife is caring for him. If the husband in that situation passed away, everything to the wife probably is the way the family would want it. But what if in that case the wife passed away first and he's the one who needs care? If she's no longer there, he may immediately need nursing home care. And this is the type of thing that we need to take into account when we look at the overall planning that the family should be doing. So, one of the things that I always tell people is it's really important to get these documents in place when you can. And remember, don't just ask the question, what happens at my death? Don't just say, this is where I want my assets to go after I've passed away. That's important, but in addition to that, remember to ask the question, what happens if I don't die, but rather become sick? What happens if I start to have nursing home costs of $5,000, $6,000 a month or more? We want to make sure that we have assets, or I should say documents in place to allow us to protect the family's assets in those cases. So I want to thank you for tuning into our series on caring for your loved one with Alzheimer's. And I want to encourage you to look around the website because we've got all kinds of information here that I think you will find of great value. And of course, if you have any questions, we're always happy to field your concerns. You can just give us a call, 913-338-5713. Again, 913-338-5713. And of course, we have lots of information on our website at www.kcelderlaw.com. Thanks so very much.